You have a chance to call the law. Keith Williams and Don Higley are here to answer your criminal and civil law questions. Call now, 561-TALK. That's 561-8255.
Every Tuesday night from 6:30 to 7, live on the radio at 103.7, The Source for talk news information, and live on your television on Greenville's Cable Channel 7. This is your chance to talk to a lawyer for free, to learn everything you always wanted to know about the law but were afraid to ask. I invite you to call us and join the conversation now at 561-TALK. That's 561-8255. Join the conversation now as I turn it over to our host, Keith Williams, and Don Higley.
Well, welcome in tonight to Call the Law. Great to be back with you tonight again live, Tuesday, May 15th, 2012. Don Higley, civil attorney extraordinaire, and myself, Keith Williams, a criminal attorney. We invite you to give us a call at 561-8255, 561-TALK. Thanks very much to our professional announcer, Michael Stewart. He'll also be taking us out, so if you enjoyed his opening, stay around for the end. He'll be giving us the outgo. 561-8255, 561-TALK. That's right, Don. You doing okay tonight?
Not too bad. How about yourself?
Doing fine. We were talking scheduling off the air. I had a case on the trial calendar this week, criminal superior court out of county, outside of Pitt County. As you know, when you get a case on the docket, if you're on there, you better get ready because you never know.
Right. Yeah, especially in criminal world.
But it's sort of like you carry an umbrella. It's less likely to rain. You get prepared, you're less likely to get called.
Right. And you would hope that they would have a little bit of courtesy to you, those folks with control of the docket.
Yeah, which in the criminal case is the DA's office. But I guess in fairness to them, they never know who's going to plead and who's not. I spent the substantial part of the weekend, the better part of the weekend, getting ready for that case and rolled in yesterday. And they said, oh, well, we've got a murder trial that's going to go for about 5 days.
Ouch. That's a long drive to Elizabeth City, too.
Yep, it was up that way. But the nice thing is, once you have your preparation done, you got it done.
Yeah, well, and that's true. And as you get older, there's less of the reinvention of the wheel, although there's always still a little bit of that for me. Some lawyers amaze me where they can say, well, I've already prepped for that, and then they just pick up the file and go in there when I have to look at it again and do a little bit of work to get ready.
Yeah, exactly right. 561-8255, 561-TALK if you'd like to give us a call tonight here with a question about the criminal law for me or a question about the civil law for Don. We invite you to call us at 561-8255. Don, I know you practice in the civil trial arena. I practice in the criminal trial arena. But it's just the nature of the beast, some uncertainty in your schedule, and sometimes I explain to people that you can only plan out but so far.
Yeah, it's funny you say that. I had last Wednesday depositions canceled. Thursday mediation, I show up at 9. The other party doesn't. This Monday, depositions canceled, and then today a doctor's deposition that I was supposed to have at 3 o'clock canceled. Imagine if everyone was like you and me and scheduled around our schedule and then showed up when we said we were going to show up, how much smoother things would be.
It would be nice, wouldn't it? But sometimes people they change their minds. They need more time. Sometimes I need more time, and I need to get a continuance. So you just have to be flexible and keep your calendar open.
Yep, you definitely have to be flexible in our business. No question about that.
561-8255, 561-TALK. Questions about the civil law for Don or questions about the criminal law for me, 561-8255. Don, I believe they also have a big criminal trial going this week, starting jury selection on Thursday morning in a murder case.
Yes. Is that the guy who allegedly murdered his girlfriend and lit her on fire?
I believe so. A case out of Farmville. I haven't seen much about the case. I've read the newspaper, and apparently he made a report that she had set herself on fire or somehow injured herself, and he called the police to come look at her.
Right. It's my work texting me while I'm talking to you. Yeah, that's the only thing I read about it was just that brief blurb this morning that it was getting started.
Right, and we actually have a judge from Elizabeth City. We have Judge J.C. Cole, who will be down here starting Thursday morning for jury selection. They'll bring the jurors in. Each side will have a chance to question them. Each side can excuse up to 6 jurors for no reason, and then beyond that, if a juror says they know something about the facts of the case or they're unable to be fair for some reason, the judge would excuse them as well. And then they'll roll into opening statements and have the trial. Don't know how long it might go. I know the murder trials can be shorter or longer depending, but this one I believe is a non-capital case. In other words, they're not seeking the death penalty, at least not that I saw.
Yeah, it will. I have actually tried 2 cases before Judge Cole. He does a great job, and he's thorough, and I'm sure he'll run a smooth ship, but he doesn't force people to go too quickly.
No, I like Judge Cole. He's got a real good temperament.
Right.
561-8255, 561-TALK. We've got Ron holding on the line. Ron, welcome to Call the Law.
Hi. I've got a question about small claims. I have commercial properties, and I write leases, of course, for my tenants. And occasionally a tenant skips out, and I have to go to small claims and get a judgment. Now, once I have this judgment in my hand, what can I do with it? I understand in North Carolina you're not allowed to attach wages, garnish wages. I don't know exactly what I can do with it. And if you'd like to take that, I'll take my answer off the air. Thank you.
Sure. Thanks, Ron. Yeah, we actually get that question quite frequently on the show. And I get that question quite frequently in my practice, where people come in and they say, Joe Schmo owes me money, $10,000. And I take them through a process of explaining to them that while he owes you money and while you can get a judgment, that can also be somewhat meaningless. Do you know what Joe owns? Does he have any assets? That kind of thing. So unfortunately, I just thought of this, it'd be nice if they had a more streamlined way that somebody pro se without a lawyer could seek a small judgment, similar to the small claims system, where instead of ending it with that judgment, they could go serve it, just like small claims is easier to get them served, get a little bit of assistance of trying to execute it, because I think execution would be a hard thing to accomplish without the help of a lawyer. So what does happen with the judgment is the clerk, without anybody asking her to, will index that, report it to the reporting services, the credit reporting services, and then anytime that person goes to buy a house or a car or anything else, both the lawyers searching their background and anybody investigating their credit is going to know about it. And so when that happens, they then have a huge amount of incentive to get the thing paid off. So a lot of times what somebody does with the judgment is nothing. They just leave it out there, let it be a thorn in that person's side, and hope that person comes back and offers to pay some money on the judgment. Or they can affirmatively call them, say, I've got the judgment. Now it's no longer in your too hard to deal with pile. It's there for 10 years, renewable for another 10 years. Do you want to try to get this thing wiped away? Or you can hire a lawyer if it's, even if it's small claims, if it's $4,500, there may be lawyers that'll go out there and try to collect that for you for a certain amount of money. And the process is you get a writ of execution, and then the sheriff goes and tries to find assets. And the sheriff doesn't have the time or the resources to really dig, so a lot of times they just ask them, do you own anything? And they say no. And anything that they can find that's obvious, they'll find. But if you're really going to find something, you probably have to get the rapidly improving skip trace computer asset search services to look into it for you, and then give them leads. We think he owns a 2003 Range Rover, which is a actual example. We got a judgment one time that they kept saying, we don't own anything, there's nothing free and clear. We got a judgment in the amount of $50,000 and sold the Range Rover for like $55,000. And by the time we paid the interest, we just collected the whole judgment and they lost the Range Rover.
Now you say it's free and clear. If that Range Rover had a loan on it, a car loan for like $10,000, you'd have to pay that car loan before you'd be able to satisfy your judgment.
Yeah, if they filed the appropriate papers that they needed to file to perfect that security interest is what they call it, then yeah, you got to take care of the 10 and you keep the other 40.
And isn't there something about exemption so that if I have a judgment against somebody, I can't come in and take every last piece of clothing and dresser and anything they may have, they're able to exempt or declare immune from the judgment certain property they need to live.
Yeah, and that's correct. And that's the first step in collecting a judgment against an individual, sending out a notice to claim exemptions, and then they have a very limited time to object. Or they have the very limited time to claim the exemptions, and then you have a limited time to object to their claimed exemptions.
Now, if they don't claim exemptions, then technically you can take every last piece of clothing and dresser and pot and pan they have.
And that's correct. Everything free and clear you can take. But, having said all that, Ron, if you're still listening after that exciting summary of how you collect a judgment, unfortunately, I think that it's very rare for somebody to skip out on a lease and not pay what's owed when they have money.
Mm-hmm.
They tend to do that because they've hit hard times. So, usually the advice to clients is, don't spend a lot of your resources on it unless you can find a lead. Or a lot of times that the person has a trust fund or happens to be from money and was a student, and it's worth pursuing. But absent that, very rare for anybody in this day and age who skips out on a lease to have any reachable assets.
If the person files bankruptcy?
And then, that would certainly be a dischargeable debt, where if they have more debts than they can pay, they can file bankruptcy. And it's a little bit harder now after changes they made a couple years ago. But, assuming that they're eligible, then you get in a pool with all the other people that the person owes money. The bankruptcy trustee gathers up all the assets and figures out what they can keep, what's left over, and what each person gets. And that's, of course, neither you nor I practices in bankruptcy, and that's a broad general way that it's done. But yeah, entirely separate system, federal court, and at the end of that, your debt's wiped out. And a lot of times, if you're unsecured, which you would be in a lease situation, unsecured meaning that you don't have a security interest or a right in a piece of property, then you end up with zero.
As opposed to a car loan, which is secured in the sense that if I don't pay it, the bank can come take the car away from me and sell the car.
That's right.
So a person who goes to get the judgment, they pay the lawyer, and they have all of that together. You're saying that when they go to execute it, they may not be able to. In fact, most likely they will be unable to execute it, and then the person can wipe it out in bankruptcy.
Yeah, and that is absolutely how it can happen.
So maybe the lesson for Ron and people in his situation is not to let people who are renting from them or people who owe them money to get too far ahead.
Right. The solution is get the security deposit. Don't let them get further behind than the security deposit. And, that's easier said than done, because if they're assuring you, I've just gotten a new job, I'll pay you next month, and it's a tough market, there's a lot of vacancies, hard to find a tenant, it can be easy to kind of let that get away from you. But theoretically, the best thing to do is not let them get past that deposit amount.
So in your business calculation, if somebody owes you money, you should figure that you can let them get to a certain point, but you should also figure that if you get a judgment, you most likely won't see anything from that judgment.
That's correct. You do have to have your eyes open that if you let them get past the deposit in terms of the debt, you may end up holding that bag and weigh that risk versus getting rid of them, getting a new tenant, trying to get a new tenant in there.
Ron, we hope that helped you. We appreciate your call tonight at 561-8255, 561-TALK. If you have questions about the civil law for Don or questions about the criminal law for me, we invite you to call us at 561-8255. Don, as you've mentioned before, you've had a broad practice in the past in terms of civil law in general. Now you focus a little more on personal injury, but we do appreciate you still answering those questions that are outside of that specific field you're working in now.
Yeah, it's I've tried a case in U.S. tax court in Winston-Salem, so I've been everywhere, man. I've been everywhere. I know a little bit about everything and nothing about something.
You know a whole lot about personal injury law.
But yeah, that's right. I do.
As we established a couple of weeks ago, you were one of the authors in a book that was published statewide on personal injury law.
I do. I think it's interesting if you run into somebody and you can remember their name a month later, it means it's because you cared.
Mm-hmm.
And if you can't the next day, it means you really didn't care about that person. For whatever reason, personal injury law just comes back to me, and I think it's just because it interests me and I care about it. Kind of like you can throw out these cases regarding search and seizure and that kind of thing. It interests you, and you know it's valuable to you, so it comes back to you.
But then my wife says, don't you remember last year we went to my grandmother's house and we saw Aunt Jean and Uncle John there, and I have no recollection.
Yeah. No. Did we do that?
Was there a Christmas last year? I just remember working.
Yeah. I remember the work part.
5618255, 561-TALK.
Yeah, did you have a good Mother's Day, by the way?
That's right, yes, I did have a good Mother's Day. It was sandwiched in between some trial prep.
Yeah, that's right. You had to prep for the trial. Fortunately, with all these cancellations I just described, I was able to go up and help my wife's mother move into a new place. So that was exciting. I unloaded all the crystal,
Very nice of
dusted
you.
it off, and
You didn't drop the mother-in-law's crystal, I hope.
I did not. The brother-in-law, her sister's husband,
Oh,
dropped a nice plate that Grandma had made.
Those guys are worthless.
Yeah, I felt terrible for him. Grandma had made this plate. So it's great grandma who's been passed away for a long time. He just dropped it, broke it.
Wow.
It was tough, awkward.
5618255, 561-TALK. Questions about the civil law for Don or questions about the criminal law for me, 5618255. Don, they may have a civil claim and try to perfect that and take it into a judgment.
Yeah, I don't think there's any son-in-law immunity. I think you can fire off a lawsuit. It'd be kind of hard to measure the damages, though.
Yeah, family immunity is a funny thing. Husband and wife, they have evidence privileges, as you know, in both the civil and criminal arena. If they're married and it's a confidential communication made during marriage that they expect it to be private, that generally is going to be held confidential. Now, if they split up, the law says there are certain exceptions to that. But beyond that, in terms of, for example, like a parent-child immunity, there is no such thing.
No, a lot of times people think, and there used to be a prohibition from a child filing a lawsuit versus mom and dad, and people sometimes still assume that's the case. Not true. And in fact, you can sue your wife for hurting you in a car wreck, because the reality is you're always seeking the insurance money and not anything from your wife, which would actually be taking money out of your own pocket.
Right, exactly. And now in the criminal arena, when I talk with clients, I'll tell them frequently that they need to talk only with me because they have an attorney-client privilege with me, and sometimes we'll talk about family members. The family members mean well, but you don't want to share a lot of details with them because you're turning them into a potential witness against you.
Yeah, and I remember occasionally on the cases where I was helping you with civil aspects of criminal cases where we had problems with the client, and it's a natural thing just to tell your mom everything that occurred, and it's also a natural thing to tell your mom something false that occurred, and then you've got a double problem because A, it's out there, and B, it's not true. So
Yeah, and you have to be careful even with what you share with your doctor or your healthcare provider, because certainly there are physician-patient privileges, but most of those by statute can be pierced, or there can be exceptions made to the privileges if a judge finds that it's quote-unquote in the interests of justice.
right, and of course they hold that you have waived any physician privilege if you file an injury lawsuit like I have. So all of that automatically comes out and is provided to the other side.
Day and age of the internet, we have no privacy. The statutes are no protection.
Yeah, and I'm sure you instruct your clients to get off Facebook as soon as they walk in the door.
Facebook is an absolute gold mine. If I'm looking for information on state's witnesses or I'm trying to see what they're saying, sometimes they are running their mouth about the case, and there's all kinds of stuff I can use.
Yeah, I think I told you that the other side told me that the defendant in a lawsuit was deployed. He's overseas, and I found him on Facebook. I said, not true.
56182.
We'll send you a link.
5618255, 561-TALK. We've got Ralph holding on the line. Ralph, welcome to Call the Law.
Thank you. My grandmother was diagnosed with Alzheimer's, and I was wondering what we could do to protect her assets. She signed the family farm over to my mother about 3 years ago, and she still has $67,000 cash in her name. And I was wondering how we could protect that if she had to go on Medicaid.
Yeah, that's a great question. Don and I don't practice in that area. I do happen to have a case that touches, though, on some of those rules. I could talk just in general. and tell you first that there is what they call a look-back period, where if a transfer is made today and then the grandmother goes into the nursing home tomorrow and says, I have no money, well, Medicare, the federal government, they're going to look back a certain period of time and say, hey, wait a minute, she transferred all this money out yesterday. We're going to treat that as her money. I don't know this area well enough to tell you what the look-back period is, but I do know it well enough to tell you that if there are transfers made that intentionally are trying to defraud the government, and I'm not saying, Ralph, that you would do this at all, but you have to be real careful with this. If there are transfers that are made with an intent to get benefits from the government that the person otherwise would not be entitled to, then you need to be real careful about that, because that can get into civil and criminal liability even sometimes. Don, I think our recommendation for Ralph would be he would need to call an attorney, an estate's attorney who practices in that area.
Right, and there are attorneys who practice specifically in the area of quote-unquote elder law, who are up to speed on these particular issues, on how to get a durable power of attorney put in place, and all of the things that you need to do your best to protect grandmother's assets.
That's right. Ralph, it's an excellent question, and we're certainly sorry to hear about your grandmother being diagnosed with Alzheimer's. But we would both recommend that you seek an elder law attorney as soon as possible, because you don't want to wait until your grandmother's condition has progressed. If she gets to the point where she's unable to manage her own affairs, then she's going to be unable to sign the papers that would be needed to give powers of attorney and that sort of thing, as the elder law attorney might direct. If you don't know of anyone, you can call either Don or I this week, and we can give you referrals to elder law attorneys, including some here in the East.
Thank you very much.
All right. Thanks, Ralph.
561-8255, 561-TALK. If you have questions about the civil law for Don or questions about the criminal law for me, we invite you to call us at 561-TALK, 561-8255. Don, as they say to us at Lawyers Mutual, the company that insures lawyers, stay in your hole.
Yeah, right. It's funny because I used to feel so guilty repeatedly because I didn't have a will or any plan like that for a long, long time, and I finally did it. So I can say on the air and not be completely embarrassed that I don't have a will and a durable power of attorney. But it's unrelated to estate planning. But I also have a disability policy because actuarially, meaning your chances going forward of you being disabled and needing that durable power of attorney versus dying is just huge. Much more likely that you'll be disabled.
But I know you agree with me when we talk about staying in our hole, staying in the area that we practice in, the area that we know.
Yeah, you can't, sometimes you really have to kind of disappoint friends. They say, they see you at a party on Friday night, I need you to draft me a will, and you'd refer them out, and they're like, well, gosh, thanks a lot. I thought I was going to do it for free, but you can't do that.
That's the classic setup situation where you do a favor for a friend, you end up stumbling into a problem, and you're not doing him or you a favor.
Yeah, because you can theoretically use your own will as a go-by or some other will and do it, or you can go on Robert Shapiro's website. But the thing is, you don't know anything about tax planning. You don't know what kind of problems you're causing when the person passes away, so it's just not a good idea.
That's right. So get a lawyer who practices in that field and get somebody who knows what they're doing. 561-8255, 561-TALK. We've got Al holding on the line. Al, welcome to Call the Law.
Hey, guys. Good evening.
How are you?
Fine. Got a question for you. I've got a small civil debt problem. I've got somebody who owes me about $400. It's nowhere... It's nobody in town, but I just wanted to see any sort of advice on. It's not a lot of money, but unfortunately, it's an attorney, and I don't know what might be my best practices because it's a small amount of money on what might be something actually to do to actually, what you guys might think to actually collect. If it's not hire an attorney or whether or not I should actually just small claims, and don't know what I should do.
Yeah, well, we do get calls frequently about debts that are, below that small claims threshold, and we routinely tell folks go out to small claims court because it's very user friendly. It's right on the website. Neither one of us have a laptop today, or we'd give you the site, but you can Google North Carolina Administrative Office of the Courts and without any knowledge or expertise, figure out the form that you need. And they also are helpful down at the clerk's office because of small claims being a system that is designed to avoid lawyers. Unlike if somebody rolls in there wanting to file a lawsuit seeking 20 grand and wants them to tell them what papers, they'll refuse. But if you go in there to small claims court knowing you need to seek 400, they will help you. And even though the person is an attorney, if they truly owe you the money, I don't think their attorneyness will get them any magical favors with a magistrate. In fact, they don't really enjoy seeing attorneys down there at all. I've only been down there 3 or 4 times in my whole career, and it's designed to exclude attorneys from there. And if that magistrate believes you that money's owed, then you'll get that judgment.
Don,
My question was,
go ahead.
It mattered because it was an attorney. That was my big question, because you would think an attorney would know pay their bills, but that's a whole other story in itself.
Yeah. No, I don't think there's any advantage. You know, obviously, if you don't have it in writing and the magistrate believes the attorney and he says, I paid him back, well then, yeah, you got a problem. But assuming you have a believable story, the magistrate...
I've got him an email. I got an email I can print out and bring.
Yeah, then the magistrate is not going to do any favors for an attorney. And if you got into a situation where the magistrate had an affinity for this attorney and you lost, you also have an automatic right to appeal within 10 days, and your magistrate will actually tell you that when he makes the decision. So yeah, I think it's, obviously there's some costs involved that are actually out of pocket, and those have been raised by our Republican legislation, so that you may
Can I ask for those too?
Oh yeah, absolutely. That'll be part of the judgment. But just the out of pocket, when you initially file it, you got to pay it, and so sometimes people say, well, if I had to pay $120 to get this thing going, I'm just going to forget about it.
Well, and Al, I would think that just filing the lawsuit and getting it served on the attorney would get his or her attention, because it would seem like they would not want to be named as a defendant and drug through small claims court.
Yeah, that's true. That's a good point, that they don't want to go downtown and especially if you have an email, it's kind of embarrassing. So
I got an email with the attorney saying they owe me the money, and my other problem is that they keep saying, well, I'm gonna send it to you, and that's what I keep wondering. Okay, well it's been probably 2-3 months. Where does there come a point with typically, because I don't know, was there come a point when you say, hey, I need to just go ahead and take this to a magistrate and just say, you guys handle it.
Yeah, well, the hard deadline that you have is 3 years from when he owed you the money. So if he said, if you gave him $400 and he said, I'll pay you next week, then you run 3 years from quote unquote next week. But obviously, the older it gets, the harder it is to prove and get somebody's attention regarding it. So, and it sounds like he may have some financial problems where you want to get the thing going and be the first to get his attention regarding the debt.
That's part of it, I think. It's just, but anyway, all right, thanks, guys.
Take
Thank
care
you.
now.
His or her
attention. Don, one thing, too, that we should mention, if this is $400 that the attorney owes to a former client, let's say the client paid them $1,000 the client paid a $1,000 fee, and then the client changed attorneys and the attorney owes back $400 and the attorney just won't pay it. In that scenario, the state bar actually has a program that's not a complaint, it's not an administrative action against the attorney, but it's the fee dispute mediation program.
Yeah, right. And that's also easy to Google and find on the North Carolina State Bar website. They have a different tab for the public, and you can find that pretty easily.
Won't cost you anything, and you can get back the $400, because normally if the bar calls to set up a mediation, I would think that would get the attorney's attention.
Right, and the attorney definitely pays at that point unless they have health problems, mental issues.
That's right. All right, coming to the end of another great show, we're going to turn it back over to our professional announcer to take us on out, Mr. Michael Stewart.
Well, thanks, Keith and Don, and thanks to everyone once again in our TV and radio audience for watching and listening. If you need help with a criminal case, call Keith Williams at his office at 931-9362. If you need help with a civil case, especially a case involving personal injury, call Don Higley at 757-7777. And that brings us to the end of another great show here on Call the Law. We hope you have a great week, and we'll see you again next Tuesday night here on Call the Law.
The law offices of Keith A. Williams online at williamslawonline.com and by Don Higley. of the Lanier Law Group, online at lanierlawgroup.com. And join us again next has been brought to you by Keith Williams from the law offices of Keith A. Williams, online at williamslawonline.com. And by Don Higley of the Lanier Law Group, online at lanierlawgroup.com. And join us again next at Lanier Law